How are you? Thanks, how are you? Good.
Me imagino, ahora sí tiene X, pues Mari le preguntaba si me cuenta. Mira, así.
Right, this is 26 CF 1570, State of Wisconsin versus Jose Bahina.
Contra José Bahina.
Appearances, please.
Preséntense los que compadecen.
Casey Dice appears for the state.
Estado.
Attorney Sarah Schmeiser makes a special appearance for Jose Bahena, who appears in custody.
Especial y él está detenido.
Counsel, have you received a copy of the criminal complaint?
I have received a copy of the criminal complaint and waive its formal reading.
Is the address on Calypso Road Mr. Bahina's current mailing address?
Para el señor Bahina.
Yes, it is.
Sí.
I've reviewed this complaint. I find that it states probable cause. What's the state's position on bail or bond?
¿Qué dice el Estado con respecto a la fianza?
State's requesting $3,000 cash, not to operate a motor vehicle, no alcohol use or consumption or possession. Cash seems appropriate to ensure future court appearances. This is currently charged as a 5-6. We are investigating one alias, which has 2 more additional OWI convictions on it. So this might become a 7th, 8th. Regardless, whether this stays a 5-6 or it becomes a 7-8, the defense facing mandatory minimum sentencing of prison. The state has a strong case. We do believe cash is appropriate.
On behalf of Mr. Bahina?
A favor del señor Bahina.
Thank you. Mr. Bahena has significant ties to the community and family here in town. His prior offenses, at least the ones listed so far, are very, very dated. And I think that a signature bond would be appropriate here.
Well, it sounds like Mr. Bahina has quite a few prior convictions for OWI, but I haven't heard that he has any history of having missed mandatory court appearances. He's got ties to the area. I think a signature bond is appropriate under these circumstances. Mr. Bahina, while this matter is pending, I'm going to order that you not operate a motor vehicle and that you not operate or that you not possess or consume any alcohol. Time limits for preliminary hearing, counsel.
We'll waive the time limits.
I'll find Mr. Bahina has waived the time limits for the preliminary hearing. We'll schedule this matter for a status. Mr. Bahina, when you leave, you'll sign your bond form and you'll get your next court date. Make sure you come back to court on that date. We are adjourned.
That's fine.
Next up is Lazaro Vinces Delgado.
You're welcome.
He's in the breakout room.
Is there a private attorney here for Vinces?
No, sorry, that's us. We were waiting in a breakout room to talk to someone for an extradition, but we'll pop back in for this.
Who are you waiting for?
Bolins and.
Okay, so you never talked to them?
Yeah.
Okay,
Not yet.
I did not think that you were able to talk to them. We will try to get after this. Yes.
Y el cajero que me sale que no
Ahora.
All right, this is 26 CM 1669, State of Wisconsin versus Lazaro Vinces Delgado. Appearances, please.
Casey Dice for the state.
Lazaro Vinces. Sorry. Lazaro Vinces Delgado appears in person in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. We have received a copy of the complaint and waive its reading. Is the beacon still the best address?
La mejor dirección para usted de Piquen,
Michelle,
en
you think,
615 East Washington.
mhm.
Okay, the address is
La
correct.
dirección está correcta.
And Mr. Vences Delgado is eligible for public defender representation.
I reviewed this complaint, find that it states probable cause, so I'll enter not guilty pleas on Mr. Delgado's behalf.
Declaraciones del no.
What's the
a favor del
state's
señor
position on bail
Betzel.
bond?
¿Y qué opina el Estado sobre la fianza?
The state is supportive of a signature bond with a ban from festival foods and no use or possession of alcohol.
Y que no se acerque a Festival Foods y que no tomen alcohol.
Any objection?
No objection.
Objeción? Ninguna.
I'll order a signature bond in this matter. Mr. Delgado, while this case is pending, I'm going to order that you not be at any festival foods location
No se acerque.
and that you not possess or consume any alcohol.
En su posesión y consumo bebidas alcohólicas.
You will be receiving a date today, that they will
Hoy
be
va a
the
recibir
same.
la fecha de la próxima fecha de
So when you leave here, you'll get your
Señor,
next court date.
saliendo de
Make
aquí,
sure you come back to
le
court
van a
then.
entregar la próxima fecha de corte y asegúrese de que comparezca en esa fecha.
Good luck, sir. We're adjourned.
Suerte, señor.
Pero si me subo, si el bar se me lleva mi carrito que tenía, se llevó todo y lo recogieron todas mis cosas y no me las entregan.
So
Y ahí
the
tengo
bus
todo,
went off with
todo.
some cart and all these
Llevo
things,
todo y
Okay.
ya no quiero.
and they don't give it back to me.
To do with that.
Estoy de Chente, y le di el número de Chente,
When,
que no sabe nada.
Okay, yeah. Mr. Delgado, when you're out, you can try to recover those.
Usted va a salir.
But the
Ok,
court
y
can't
puede
help you with that
recuperar sus
today.
cosas o tratar de recuperarlas. El corte no le puede ayudar con eso, solo con la fianza. Ok, pase con el señor oficial.
Señor,
El señor oficial, por aquí. Pase con ellos.
let's go try the breakout room again. Cool. All right, this should be everybody.
Thanks, Amy. You have.
I have Toddy, TOGTY. Casey.
No,
Southern female about, is it Johnson, right on your side, is everything look good? Yep, Dwayne, all right.
Dwayne, who-
That was Kellen Toddy. Toddy, all right, next up is Kellen Toddy. Yeah, let's sit on this. Kellen Toddy.
This is 26 CF 1568, State of Wisconsin versus Kellen Toddy. Appearances, please.
Casey Dice appears for the state.
Mr. Toddy appears in custody with counsel Merle Josty. Good afternoon, Commissioner.
Good afternoon. Have you received a copy of the criminal complaint?
We have a waive reading. The address is correct.
I've reviewed this complaint. It states probable cause. What's the state's position on bail or bonds?
The state is cognizant that this is a signature bond case. Being young, this is his first offense. We are asking for no unsupervised contact with minors. And I'm not sure if the court has any standard language they like to use about use of file sharing websites like Discord and Kik and that sort of thing, limiting their use.
On behalf of Mr. Toddy, any position?
We don't have any objections to those conditions.
All right, order signature bond in this matter. That is consistent with the recommendation of the public safety assessment that's on file and the sort of joint recommendation of the parties. I'll order while this case is pending, Mr. Toddy, that you not have any unsupervised contact with any minors and that you not use any file sharing services such as Discord or Kik. Preliminary hearing time limits?
We'll waive time limits.
Fine, Mr. Toddy, so we have the time limits, we'll schedule the matter for status. So when you leave here, you'll get that next date. Make sure you come back to court.
Right now, I'm looking at August 10th, 2/20.
That date is fine, August 10th, 2/20. Thank you.
Thank you.
We have someone here who has a Somali interpreter, which means they have to go next just because of what it costs for the interpretation.
Got it.
So if you guys want to come back in and then we'll.
We'll be doing the case for Ahmed next. We have a Somali interpreter.
Is that, okay. You say Ahmed? Oh, I see. Okay, I see. All right, is the interpreter ready?
The interpreter is ready, Your Honor.
This is 26 CM 1661, State of Wisconsin versus Ugaso Ahmed.
Wala tan iyo lix ama saasama dacwadda ka dhaxaysa Ugaaso Axmed iyo gobolka Wisconsin.
Appearances, please.
Casey
Dadkii
Dice.
jooga maxkamadda ha is sheegaano.
Casey Dice appears for the state.
Tiis oo ka socda dhinaca gobolka.
Ugaso Ahmed appears in person in custody.
Ugaaso Axmed oo maxkamadda horteeda joogta gacantana lagu hayo.
By student attorney Caroline Scott.
Caroline Scott ayaan ahay, waxaan ahay qareenka u doodaya.
Under the supervision of attorney Frederickson.
Waxaana kor igala socda qareenka magaciisa la yiraahdo Frederickson.
We have received a copy of the complaint.
Waxaan helnay koobi ka mid ah dacwadda laga soo gudbiyey.
And waive its reading.
Waa iska dhaafna in loo akhriyo.
Is this the correct address?
Tan ma yahay ciwaankaaga saxda ah? Yes.
The address is correct.
Ciwaanku waa saxan yahay.
And Ms. Ahmed is eligible for public defender representation.
Waxayna xaq u leedahay in la siiyo qareenka dadweynaha ee u difaaca.
I've reviewed this complaint. It states probable cause. I'll enter not guilty pleas on Miss Ahmed's behalf.
Marka waan akhriyay dacwadda iyo sababta loo qaateenka ee lagu soo qabto ano iyada ka wakiila Marow Axmedna waxaan u gelinayaa dacwaddaas inaysan qabin.
What is the state's position on bail or bond?
Lacagta ama damiinka lagu sii deynayo waa maxay mowqifka uu taagan yahay gobolku?
The state's asking for $600 cash, no alcohol. Sorry. Okay, go ahead.
$600 oo caddaan ah iyo inaysan isticmaalin alcohol.
No alcohol, no contact with Umbeni P,
Waa inaysan la xiriirin qofka la yiraahdo Mpini B.
a ban from the victim's residence,
Waxaa ka mamnuuca qof meesha uu degan yahay dhibanuhu.
The defendant had just previously posted $300 on July 16th. After
Sorry, shalay tobankeed waxay dhigtay lacag damiin ah oo $300 ah.
after violating the conditions of bond in a prior case.
Waxayna ku xadgudubtay shuruudii lagu sii deeyay kiiskan kiis ka horreeyay.
And then within hours, she's being picked up from the jail by the victim. The defendant was found intoxicated and causing the disturbance outlined in the complaint.
Markii laga saaro ka qaaday qofka dhibanaha xabsigana saacada gudahoodana waxaa la helay iyadoo cabsan oo cabasho laga soo gudbiyey dacwad laga keenay.
Nothing further.
Wax kaloo dheeriya ma jiraan.
On behalf of Ms. Ahmed,
Your Honor, we would be,
Marow Axmed,
Your Honor, we would be requesting a more nominal cash amount.
waxaan codsanaynaa lacagta ugu yar ee caddaanka ah inta ugu hooseysa.
Ms. Ahmed is eligible for public defender services.
Waxay xaq u leedahay in la siiyo adeegyada qaranada dowladda ee lacag la'aanta ah.
She is also the sole caretaker of her daughter Alicia.
waana keliya qofka keliya xanaaneeya gabadheeda Alicia.
And looking at the case information here,
Markaan fiiriyo xogta ku qoran kiiskan halkan,
it suggests that this is all related to a drinking problem.
waxayna u
And
muuqataa
we,
dhammaan arrimaha inay la xiriiraan cabitaanka khamrada.
and we should not be warehousing people in custody for that.
Mana aha dadka inaan ku aruurino xabsiga ku hayno sababtaas darteed.
She was arrested without incident,
Waxaa la xiray idan wax dhiba geysan.
and for those reasons, we would be requesting a more nominal amount.
Sababtaas darteed waxaan codsanaynaa in lacagta ugu yar ee suuragalka looga dhigo damiin.
What about the non-monetary conditions requested?
Maxaad codsanaysaan oo shuruudo ah oo aan lacag ku xirayn?
I believe that the state requested a ban from the victim's residence, not her own residence. I think those are two different.
Laba shay oo kala duwan. Waxaa laga mamnuucay inay tagto meesha uu degan yahay qofka dhibanaha ah. Lagama mamnuucin guriga ay iyadu degan tahay. Waa tegi kartaa. Taasna waa laba shay oo kala duwan.
Okay. What address is that ban?
We're asked,
Adreeskaas waa kee?
we're asking for a ban from anywhere where the victim resides. We don't have a specific address
Okay.
at the moment.
Waxaan codsanaynaa meel kasta uu degan yahay dhibanuhu. Hadda ma hayno cinwaan gooni ah, laakiin meel kasta uu degan yahay qofka dhibanaha inaysan tegin ayaan codsanaynaa.
So in that case, Your Honor, we would object and instead ask for a no threats of violence condition. That is Miss Ahmed's house.
Marka
And he stays with her.
iyaduu la joogaa gurigeedana inaysan laga mamnuuci karin iyaduna la joogaa.
Attorney Dice, can you spell the name of the person with whom you're requesting no contact?
Maxay codsanaysaa qofka codsanaya inuusan la xiriirin?
OMB as in boy, ENI.
Waa o ma ba e na I ombeni.
What was their last initial?
P.
Magacood dambeena maxaa la soo gabay waa B.
It's your lease. Okay. Just see what she's got.
Right, I was just reviewing CCAP to determine whether or not Ms. Ahmed has missed any mandatory court appearances.
Waxaan fiirinaya wax loo yaqaano CCAP-ka waxaana fiirinaya haddii Ugaas Axmed ay maxkamado hore ay aheedo inay timaado ay u goysay oo imaan weysay.
It doesn't appear that she has yet had the opportunity. It does, because it doesn't look like she's had any court appearances yet, having been charged so recently.
Uma muuqata haddii la siiyey fursadaas iyo haddii maxkamado ay timiday waqtiyada dhow ay jireen.
There's a public safety assessment on file which notes no prior convictions and no prior missed appearances.
Waxaa ku yaala ammaanka dadweynaha markii la fiiriyey hore maxkamad ay u goysay ma jirto, xukun hore oo ku dhacana ma jiro.
The allegations, though, are that Ms. Ahmed violated the conditions of her release almost immediately afterward.
Waxaana aada lagu soo eedeeyay isla markiiba inay ku xadgudubisay ama ay jebisay shuruudihii lagu sii daayay isla markii la sii daayay.
There is some reason to believe, therefore, that she will not come to court as required.
Marka waxaa jira sabab lagu aamini kara inaysan maxkamadda ku soo laaban doonin sida looga rabay inay u soo laabato.
For that reason, I'm going to order $400 cash bail.
Darada waxaan amrayaa $400 oo caddaan ah oo damiin ah.
I think given what's contained in the criminal complaint, no contact with Umbeni Key is appropriate.
in marka la fiiriyo cabashada inaysan la xiriirin on beena bina waa wax habboon ay mamnuuc ka tahay.
I will also order that Ms. Ahmed not possess or consume any alcohol.
Waxaan kaloo amrayaa inaysan haysan oysan isticmaalin wax alcohol ah.
It is not entirely clear to me whose residence, whose residence this is, and so I'm not going to order the residence ban. I think the no contact should cover it.
Marka waa amarka isula xiriirin ayaa ku filan, ma aqaano gurigan qofka iskale iyo qofka degan, laakiin amarka looga mamnuuca inay la xiriirto ayaa ku filan.
Ms. Ahmed, when you leave here, you'll get your next court dates. Make sure you come back to court.
Marka halkan ka tagto waxaa lagu sheegi doonaa maxkamadaada xigta waqtiga la qabanayo, hubi inaad maxkamadda soo xaadirto.
Okay. And then we'll be
Okay.
adjourned.
You'll get an attorney appointment.
Maxkamaddan waa dhamaatay.
All right, we're adjourned. Thank you, everybody.
Dhamaantiin waa mahadsantihiin, maxkamadda waa noo gabagabowday.
Mhm. They'll take you back and they'll give you information about how to post that.
Did we want to have the breakout room with the other air condition now?
Yes, let's do that. Before during.
You guys just watching today?
No, I have. We're gonna try and break up. Okay.
Sometimes Casey, I just want to hang out with you.
Yeah, it's fine.
And you always turn me to shit.
Oh.
Like, Casey, come to my house, watch a movie. And you're like, no.
Good.
You better. Right, this weekend. Great. It's for you.
Huh?
All right, this is 26 BF 792, State of Wisconsin versus Damari Kemp. Appearances, please.
Casey Dice appears for the state.
Good afternoon. Mr. Kemp appears in person law with counsel Reed Cornea. You know, we have received a copy of the complaint in this case.
Oh,
Is this not
there was already
It's just about. Yeah.
there was already an initial appearance on this case back in April.
Correct.
It appears that Mr. Kemp failed to appear at a preliminary hearing April 14th.
Yes. He was in custody in Cook County Jail at the time. He just completed his sentence in Cook County for Illinois, and he began the process of trying to get here and in Walworth County back in towards the end of June, middle of June. As you may have experienced with Cook County, trying to get a hold of people there is a very difficult process. We were finally able to get hold of some individuals. I put the motion in to have him brought here, or at least have it quashed by Zoom if we could, if that's the way we could do it. He did have a hearing in Walworth County, where his other case is pending in Dane County. And these are the only two cases that he has in Wisconsin.
The address that we have on file right now, this says Cook County Jail. Is there a better place that we should be sending it?
Well, so this is, it depends on what happens here today. So it looks like Dane, so on the seventh, when Walworth County had a hearing, he was still in Cook County. They just did it by Zoom. My guess is Dane County has the first detainer on him. And because you guys brought him up here. If,
I'll just use the jail.
yeah, I'm overcomplicating it probably, but
Is there any position on bail or bond from the state?
So I'm looking at Walworth. It looks like he had $10,000 posted in Walworth and that was recently forfeited on May 26th.
He's currently being held out for County.
Right,
Yeah.
so
and that, again, it goes back to his serve at the time that he did in I believe that goes back to the time he did in
right.
Cook County. How long were you in Cook County jail again? Oh, I'm generally speaking, no, but he wants to explain the situation to him. That might be
Let
easy.
me,
We just,
let's see.
hold on a second, sir. Let's just have this one at a time, okay?
He was previous, yeah, he was previously given a signature bond and a ban from Walmart. I think we should keep the non-monetary condition. He did miss. I realize he was being held in custody in Chicago. He was extradited from Chicago, so I recognize that he, I don't want to say missed for good reason, but there was an excuse, right, as to why he missed. So I think we're likely in a position where we just reinstate the signature bond, which just seems wild to say for somebody who just had $10,000 forfeited in a neighboring county, but
I guess I should note that he's also being held on an expeditable warrant from Indiana. I'm not sure the nature of it, but one of the fields has a notation that says carrying prohibited weapons.
yeah. We have him on one count of felony retail theft. I think a signature bond and let him get on his way to more pressing matters elsewhere.
Any objection?
No objection to the signature bond.
All right, I'll reinstate the signature bond with that one condition. Mr. Kemp, it sounds like you're wanted in a number of places. If you end up somewhere else, and in the position that you were in when you missed this preliminary hearing, you're going to want to stay in as close a contact as you can with Attorney Cornea and the court to let people know where you are. I don't think you have to say anything. I'm reinstating the signature bond, meaning you don't have to pay any bail to get out, to be released from this case. It sounds like you got some other stuff that might be holding you.
I know your mom has that number. I'll call her.
All right, we're adjourned. Wait, do we have to schedule another preliminary hearing or there was already a time waiver? Oh, okay.
Yeah, it's been, yeah.
I missed that one. Okay.
Thanks, guys. Have a nice afternoon.
You too.
I'll reach out to you, Mom, okay?
In court, in court.
If they're still there. Which one are you doing first? Which one of the extras? Okay.
Next up will be Joseph Levitt. Everybody's doing from Oakville. For our next division. He's currently stuck in the breakout room and has a 60-second timer after I click close, which I did take 20 seconds ago. I said there's something you can click on to come back instantly, but I can't do that. Should we click that one? Oh, I don't know, so. He apparently wants to wait, but he has decided in the problem, so. I'm thinking they're gonna recall tomorrow, maybe, I don't know.
We need it today, or we need to step on today if he's not waiting.
No, super needs to wait.
I know.
That's just safe. That's just safe. Oh,
Yeah, that's fine. All right, this is 26 CF 1572, State of Wisconsin versus Joseph Leddit. Appearances, please.
Casey Dice for the state.
Joseph Leddit appears via Zoom in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. And it is my understanding that Mr. Leddit, having been advised of his rights, wishes to waive his extradition hearing and is prepared to sign the waiver paperwork.
All right, Mr. Leddit, did you hear all of that?
Yes, ma'am.
And is all of that accurate?
Yes, ma'am.
All right, all of that's just fine, Mr. Leddit, but I have to talk with you about a couple of things. If you give up the right to fight extradition, or if you waive extradition, you're giving up a number of other rights as well. It's first of all, the right to have me set some sort of bail in this case. Often in these sorts of cases, what you're talking about is some cash bail. But I'd listen to the arguments and I'd make some decision on bail. You're also giving up the right to have a lawyer who could assist you at a contested extradition hearing here in Wisconsin. You're giving up the right to have a warrant signed by the governor. You're giving up the right to a process called a habeas process, where a judge would look at, I'm sorry, I think I keep saying Illinois and I mean to be saying Texas. But a judge would look at all of the paperwork from Texas and make sure that everything is in order. The other side of it is you're welcome to waive extradition. If you do that, you'll have essentially I'll remand you to the custody of the sheriff, and we'll have the state of Texas informed that you're ready to be picked up, and they will get you down there. So Mr. Leddit, did you understand everything I just said?
Yes, ma'am.
And knowing all of that, do you still wish to waive extradition?
Yes, ma'am.
Still got this little guy's name. Mr. Leddit, if you were here, I'd have you review this document with your attorneys. I'm going to just read it out loud, and then you can tell me whether or not this is what you agreed to. There's a waiver of extradition form here. It says that I, Joseph Leddit, hereinafter referred to as defendant, having been fully advised in court in the Dane County, Wisconsin, in respect to my rights my rights to demand extradition proceedings and to demand legal counsel to represent me in any proceedings I might wish to institute to obtain a writ of habeas corpus, do hereby willingly and voluntarily agree to waive any and all extradition proceedings and consent to return to the requesting state in the custody of such agent of said requesting state as may be sent to return to me to answer to the charges of aggravated robbery. Mr. Leddit, I'm just gonna ask you one more time that you are waiving your right to an extradition hearing, right?
All right.
All right. I will remand you to the custody of the sheriff. I will sign this waiver form here, and hopefully Texas will come to get you sooner rather than later. Is there anything else either of you think I'm missing here?
I
Okay.
have no idea.
All right, then we're adjourned on that. Thank you, Mr. Leddit.
All right, you're welcome.
Court's done.
All right, next up is Christopher Bullins. Hearing by Zoom for an extradition. Okay. You, the same story.
I don't, I just.
Oh, good.
See also right now.
He's waiting, yeah.
Yeah, why don't you do that?
This done. Is that the done file?
So,
Okay.
oh. Mine, I'm not heard of this.
All right, this is 26 CF 1506, State of Wisconsin versus Christopher Bullins. Appearances, please.
Casey Dice for the state.
Christopher Bullins appears in custody via Zoom and by attorney Paul Frederickson and court commissioner. I did have the opportunity to discuss with Mr. Bullins his right to extradition. He had the opportunity to discuss that more fully with his assigned counsel, Laura Bruin. He had no further questions for me and wishes to waive his rights to extradition today.
Is all of that correct, Mr. Bullins? Mr. Bullins, can you hear me? Mr. Bullins, can you hear me?
Yes, ma'am.
Okay. Did you hear everything that Attorney Frederickson said?
Yes, ma'am.
All right. And was everything he said accurate?
Yes, ma'am.
All right, Mr. Bullins, since you're telling me that you wish to waive extradition, I want to talk to you about a couple of things. I want to talk to you about the rights that you're giving up by waiving extradition. The first is you're giving up your right to have a lawyer who could assist you at a contested extradition hearing here in Wisconsin. I assume that you understand that because it looks like the public defender has appointed a lawyer to you already. Do you understand that?
Yes, ma'am.
You're also giving up the right to have a warrant signed by the governor, and you're giving up a right to have a process called a habeas process, where the judge would look at all of the documents from Iowa and make sure everything is in order. They essentially have to prove that you're the person they're looking for in Iowa. Do you understand all of that?
Yes, ma'am.
And Mr. Bullins, do you feel like you had enough time to talk with your lawyer about this decision?
Yes, ma'am.
And you still wish to waive extradition?
Yes, ma'am.
All right, Mr. Bullins, I'm going to, if you were in the courtroom here, I would give you a form. It's a waiver of extradition form. I'm going to read it to you, and then you can tell me whether or not you would like to sign this document, sort of, if you were here, you would sign it. It says, I, Christopher Bullins, hereinafter referred to as defendant, having been fully advised in the circuit court for Dane County, Wisconsin, in respect to my rights to demand extradition proceedings and to demand legal counsel to represent me in any proceedings I might wish to institute to obtain a writ of habeas corpus, do hereby willingly and voluntarily agree to waive any and all extradition proceedings and consent to return to the requesting state in the custody of such agent of said requesting state as may be sent to return me to answer to the charges of robbery first, theft in the first, false imprisonment, obstruction of emergency communications. Mr. Bullins, having heard all of that, do you wish to waive your right to an extradition hearing?
Yes, ma'am.
All right, then I'll sign this document. I will remand you into the custody of the sheriff, and hopefully I was here to pick you up sooner rather than later. Good luck, Mr. Bullins. Oh, wait, I'm sorry. Let me check about-
Thank you.
Thank you. I left the date up for that one.
All right, next up is Kelly Hudson. What's it? Well.
26 CF 1571, State of Wisconsin versus, is it Centelli? Centel?
Yes.
All right, Centel Hudson, appearances, please.
Casey Dice appears for the state.
Centel Hudson appears in person in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. We've received a copy of the complaint and waive its reading. Mr. Hudson is eligible for public defender services, and he has an address that he would like to update to.
Go ahead whenever you're ready.
2418 Winnebago Street. You might as well.
Is there an apartment number?
205.
Can you know the zip code?
53704.
Thank you.
All right. All right, I've reviewed this complaint. It states probable cause. What's the state's position on bail or bond?
So the defendant appears to be from out of state, in Illinois, Chicago area, or Hammond, Indiana, it looks like. His only prior contact in Wisconsin, or this is his only contact in Wisconsin. That being said, the conduct outlined in the complaint is incredibly dangerous. He fled from law enforcement after officers believed he was a participant in a drug buy. He drove very fast. He lost control of the vehicle. He crashed. He then fled from the vehicle on foot. We're asking for $5,000 and not to operate a motor vehicle. What's most alarming about his behavior is the defendant seemed to have knowledge of, despite not being from here, he seemed to have knowledge of our pursuit policies and whether or not officers would pursue a fleeing vehicle. He then said that he does the same thing in Chicago. When law enforcement wants to stop him, he just drives away fast. That to me is a pretty good indicator of somebody who will not voluntarily return to court, right? So for those reasons, I think cash bond is appropriate.
On behalf of Mr. Hudson.
Yes, Your Honor. While we understand the seriousness of the offenses here, we would be asking for a much more modest cash amount be set. As I mentioned, he is eligible for public defender services, so he is indigent. He's also been living in Wisconsin for 6 months and not had any other police contact, which I think indicates that it's possible that this was just a one-off event. And yeah, again, as the state mentioned, he has no other criminal history within the state. So we would be asking for a much more modest cash amount that would reflect the seriousness of the offense, but that would be postable for Mr. Hudson.
Attorney Dice, is that what you said? Is that there's no?
I said this.
History? I know that you said that he has no contacts with Wisconsin, but.
That is what I said. I said this appears to be his first criminal contact with Wisconsin authorities. I do have the NCIC from out of state. He does have what I can say is a fair amount of charges, or at least referrals in Illinois, etc. These do take a fair amount of time to digest on the spot. I can search for some keywords. I searched for escape, for instance, and I did see one from 2025 in Park Forest Police Department. That being said, I do not feel comfortable saying like he's been convicted of XYZ, but I can tell you he's got 28 pages of various contacts.
Your Honor, can I respond just on some information that I
Sure.
learned from Mr. Hudson? He informed me that on one of the charges that Attorney Dice just mentioned, he turned himself in, and he actually has not faced any new charges in a few years. So,
Well, what's alleged here in the criminal complaint is sufficient to cause some concern about the likelihood that Mr. Hudson is going to come to court here in Wisconsin. The complaint accuses him of fleeing from the police, and then apparently, according to this complaint, said that this is what he does in Chicago. And that it was no big deal. So I do think there is plenty of reason to be concerned that Mr. Hudson is not going to come to court here in Wisconsin as required. I think the state's request for $5,000 is appropriate here. That's what I'll order. I'll order, Mr. Hudson, that you not operate a motor vehicle while this matter is pending. Should we schedule the preliminary hearing within the time limit?
Yes, with it, would like to keep time.
That's what we'll do. We'll be adjourned on this matter.
Next up is Billy Johnson, hearing by Zoom for a formal service. By this way, sir.
All right, are you Mr. Johnson? I can only see, hi, are you Mr. Johnson? I can only see a portion of your face.
Yes,
Okay, this is 26 FO 1353 Dane County versus Mulligetta Johnson. Appearances, please.
Casey Dice for the state. The defendant appears via Zoom from Dane County Jail. And I'm appearing for the county, so, well,
It's okay, it's not recorded, so I know who you're here for. Mr. Johnson, I have in front of me a forfeiture complaint. It charges you with one count of county theft. Oh, where did he go?
Didn't seem like maybe there's actual problems, the audio is already.
Okay, we'll move on to the next one. Wait for him.
Like they're reconnecting.
Okay.
More importantly, I'm not sure that we have anyone else that we can serve.
Oh.
They can hear us, they just can't see us, so I'm hearing. So it looks like it might.
Frozen, yeah.
Are you folded back up over there or are you frozen?
see if he wants court cause.
Indicated that it's back up over there.
But there's some backup.
They can see us now.
Can they hear us?
He's he said earlier they can hear us. Just to clarify, you can see us and hear us.
We're not talking, so.
You can see us and hear us.
All right, Ms. Johnson, I'm going to give this speech and then hopefully we can find out whether you heard it, but I'm going to just talk for a little bit. I have in front of me a forfeiture complaint. It charges you with county theft. It's a non-criminal ordinance violation. It carries no potential jail sentence, just a forfeiture of money only. I will ask you how you wish to plead to this. You should know, though, that no matter what your answer is, this matter will not continue to hold you in jail. I don't know whether you're being held in anything else, but this is not going to keep you in jail any longer. Sometimes the county wishes to make an offer to resolve the matter. I think I heard Attorney Dice say earlier that the county would offer you court costs if you want to enter a guilty or no contest plea. That would mean that I would order that you pay $114.50. Did you say yes, please?
Right, TV consider here the other option.
I'm going to finish explaining to him. I just want to make sure he can hear.
Stated no contest.
So.
Okay, Mr. Johnson, I'm just going to finish talking, okay, and then hopefully I can hopefully I can hear what you have to say. If you enter a not guilty plea, we'll schedule the matter for further proceedings, and you can talk with the prosecutor about resolving the matter in a different way or have a trial if you'd like. Hopefully the audio will come through. Go ahead and tell me how you wish to plead to this.
no contest.
Okay. I'll find you guilty based on your no contest plea. I'll order that you pay court costs, $114.50. That's due in the next 60 days. Good luck, sir.
Thank you.
Next up is Tyjon Robinson. Back over here.
This is 26 CF 1407, State of Wisconsin versus Tyjon Robinson. Appearances, please.
Casey Dice for the state.
Tyjon Robinson appears in person in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. We have received a copy of the complaint and waive its reading. Is the best address for you? Okay. The address on the complaint is correct, and Mr. Robinson is not eligible for public defender representation.
All right, Mr. Robinson, sounds like you're not eligible for public defender. You have a right to be represented by an attorney here. You've been charged with a felony. First, oftentimes people's first contact is with the public defender, but if you're not eligible for their services, your options are to hire an attorney to represent you or to apply with the court and ask the court to appoint an attorney to at county expense. You'll need to take the documentation from the public defender showing that you are not eligible for their services to the clerk of court when you apply. I think the bailiff probably just provided you some information about that. I have reviewed this complaint. It states probable cause. What's the state's position on bail or bond? And Attorney Dice said, I don't know if you know, I understand that Mr. Robinson was extradited here from Illinois.
From where, I'm sorry?
Illinois.
Okay, yep. I do see that he was extradited from Illinois. My understanding is he is a resident of Illinois. He does not have Wisconsin contacts to my knowledge. Still showing an address in Cicero, Illinois. Let me check statewide to see if we've ever seen him in Wisconsin. No, it appears this is his only law enforcement contact in the state of Wisconsin that at least rose to the level of referral to any district attorney office across the state. He is, what is it, 28 years old? 28 years old, and he is alleged to have stolen $80,000 from Wyawega Cheese. Obviously, that's a huge amount. He's from out of state. First, we're asking for no contact with Wyawega Cheese, and we're asking for $5,000 cash, which is frankly just a fraction of what he stole and has already spent. So nothing further. Absent any questions?
On behalf of Mr. Robinson.
Yes, Your Honor, we'd be asking for a signature bond or at the least a much more modest amount of cash here. These are nonviolent property crimes and they're pretty old at this point. As the state mentioned, he has no other criminal history in Wisconsin. He's not a risk to the public. He hasn't had further police contact. He's been employed for nearly a year and a half, and I believe that it's even mentioned in the complaint that he's been living in that same apartment for several years at this point. So I think that he is reliable, and we can count on the fact that he'll appear in court.
Does Mr. Robinson have the ability to get from Illinois here?
Yes.
And did you say that the address on the complaint was his accurate address in Cicero?
That's correct, yeah, which is Chicago, right? Just right outside Chicago. Yeah. So not very far.
Well, Mr. Robinson has no, first of all, I'll say that this is not an Act 3 eligible charge here. So the question is whether or not Mr. Robinson is going to come to court as required. I have that he's 28 years old, and I haven't heard that he has any prior criminal history or history of having missed court. He, on the other hand, doesn't live in the state and apparently has no contact with the state, but does live in a neighboring state. I think what I'm going to do, Mr. Robinson, is order a signature bond in this case. I'm going to give you the benefit of the doubt here and not require that you pay any cash to be released from jail. If you fail to appear in court, though, there will be a warrant issued for you. You will find yourself in the same position And it is not likely that who's ever sitting in the seat is going to come to the same conclusion. As a condition of your bond, I will order that you have no contact with Wyomega Cheese. Time limits for the preliminary hearing, counsel.
So you have the right to. So you just have the hearing out further. It's that it, you can underscore, go back or come to Madison and have an attorney. Are you okay with waiving them? Otherwise, they would have to set it within 20 days from today.
Okay, we'll waive time.
All right, I'll find Mr. Robinson is waiving the time limits for the preliminary hearing and schedule the matter for a status. Mr. Robinson, you're going to get the date for the status when you leave here. You have to be back in Wisconsin on that date. Whether or not you have an attorney, but you should take some steps to get some to get an attorney if we want one between now and then. Okay. All right, we're done.
All right, sir, Frank Slayer. Next up is Connor Braverman. Braverman, this is you.
This is 26 CF 434. State of Wisconsin versus Connor Braverman. Appearances, please.
Casey Dice for the state.
I'm sorry, before you do that, Attorney Dice, I missed a couple of them. There are 3 cases. I just told one. The other 2 are 26 CM 1664 and 26 FO 1351. Go ahead.
Casey Dice for the state and the county.
Connor Braverman appears in person in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. We have received 2 complaints. And we'll waive their reading. I don't know.
26 CF 434 is just a bail bond.
Bail bond hearing. Okay, then we've received copies of the complaints and waived their reading. Mr. Braverman is eligible for public defender representation and is 405.
Correct.
Okay, and the address on the complaint is correct.
It's like there was already an initial appearance on the CF case. Well, before I get to that, with respect to the CM case, I've reviewed a copy of the criminal complaint and find that it states probable cause will enter not guilty pleas on your behalf, Mr. Braverman. With respect to the CF case, it looks like there was a warrant issued after Mr. Braverman failed to appear at a status. It was a status on July 10th. Counsel, any explanation for the missed appearance on July 10th?
Your Honor, I spoke with Mr. Braverman's attorney this morning, and I think that Mr. Braverman has been struggling. He did not have a phone at the time, and I think there was just a miscommunication about the court date. But he has previously been appearing several times on signature bonds. And as far as I can tell, I think that this is the first time that he's failed to appear.
What is the state's position on bail or bond?
For the bail bond hearing, we're asking for a SIG bond reinstate conditions. Counsel is right. This was his first miss. He's appeared several times on this case. For the new case, we're just asking for a SIG bond with standard conditions. No new crimes.
Any objection?
No objections.
I'll order a signature bond in each case. The conditions on the CF case will be the same. All right. The FO case, it makes sense to track along with the other 2, I think, unless anybody has a different thought about that.
I mean, I'll always take a plea, but it makes sense to track along.
Counsel, I saw you nodding.
Sorry, yes, no objection. Yeah, I can track along, please.
All right, then these will both be scheduled with the branch. Mr. Braverman, make sure that you stay in contact with your lawyer about this, about your court dates.
I will.
Okay.
Yeah, that was my mistake.
All right, free to go.
All right, start this way. Next up is Nicholas Baranski, appearing by Zoom.
All right, I see someone on the other side of that red door. Is that you, Mr. Baranski? If it is, you can just give me a sign, a wave, a thumbs up. Great. This is 26 CF 1569, State of Wisconsin versus Nicholas Baranski. Appearances, please.
Casey Dice for the state.
Attorney Derek Brown appears on behalf of Mark Eisenberg, appearing on behalf of Nicholas Baranski. I have received a copy of the criminal complaint, would waive its formal reading, stand mute to the misdemeanor portions of the complaint. I would object and move to dismiss the domestic enhancer on each of the counts. It states pretty clearly in the complaint that the defendant does not live with the alleged victim, and there are no further allegations that the two were ever married or shared a child in common or ever formally resided together. So I don't think that's appropriate to have those when the complaint establishes they do not have a domestic relationship.
All right, Attorney Dice, any position with respect to that motion?
I would need a few minutes to review the complaint
Sure.
regarding that issue.
Then let me know.
Sure.
I'll do the same.
I can point to page 3 of the complaint in the first full paragraph, about 3 lines down. It says
That part.
the defendant hereinafter who she doesn't live with.
Yeah, I'm not seeing anything in the 4 corners of the complaint. I think counsel is right. Obviously, we reserve our right to reissue it with some additional details or amend it with additional details if necessary.
All right, I'll grant the motion on the enhancers. I've reviewed the complaint and otherwise states probable cause for the remaining charges. What's the state's position on bail or bond?
Sure. State's asking for $2,500, no contact with Kaylee R. Banned from any place she temporarily occupies, not to go armed, and to surrender any firearms while case is pending. He is charged with a Act 3 eligible offense. The facts alleged in the complaint are serious. The victim reports being afraid of him, being concerned. In the allegation, he came over to her apartment, as defense pointed out, right, and would not leave her residence. He attacked her physically during that. I guess if he still has keys to her apartment, we'd also ask that he surrender those as well. I think this is one of the reasons Act 3 exists, right? To give victims peace of mind. So given that this is an Act 3 eligible offense, I think $2,500 cash and the non-monetary conditions makes sense.
On behalf of Mr. Baranski.
Yes, we would object to a cash bond. We would request a signature bond. have no objection to the no contact. With the no contact comes he leaves any place that she temporarily occupies, so I don't think it's really necessary to include that. That's just kind of doubling the language. I would object to conditions to not go armed, would object to a condition to forfeit firearms. Regarding.
I'm sorry, counsel, you said you do object to those?
Yes, correct. I would object to those. I would note, Mr. Bransky has absolutely zero criminal history. He has lived in Wisconsin his entire life, has substantial ties to Wisconsin. He just purchased a home in Greene County with his partner of 11 years, who's a public defender in Rock County. The allegations here, I read through this complaint. I've been sitting back there for half an hour, 45 minutes. It's one of the weirder complaints I've ever read, I have to say. It's kind of all over the place in terms of when allegations are made or why allegations are made. Apparently, there's an initial allegation made on May 26th for events that occurred on May 25th. But at that point in time, she refused to identify him. Then she calls the police on July 10th to report an incident on May 8th that happened, which is very similar to the events apparently that occurred on May 25th. She still at that point will not identify him. And then eventually on July 16th, she meets with police in person and then identifies who it was. So it's very weird. I don't really know what to make of that. I would note that I think that July 16th is relevant in that there is currently an active TRO that Mr. Baranski filed against this individual, and that was granted on July 14th. Shockingly, after she likely received that, she then identifies him to police on July 16th. I wonder if that's connected. So I think when you consider those things, right, when you consider the kind of vagueness of the complaint, he locked her in a room, and then when she would leave the room, he would tackle her onto the bed. But then sometimes she was allowed out of the room, sometimes she wasn't allowed out of the room. There's kids present, there weren't kids present. She had her phone, she didn't have her phone. It's all over the place. Even if we don't consider that, it's pretty clearly stated in the complaints that the last physical altercation between the two, according to the victim, occurred on May 25th of 2026. That's about 2 months ago. So we now have 2 months of essentially okay conduct or contact between these individuals, according to this person. I think my client would disagree that they've had contact at all. So this is not a case where this just happened. He just got put in jail, that no contact and forfeiture of firearms is necessary to protect her. We've had 2 months to establish that those things aren't necessary because they have not been in place, and she has not been threatened. She has not been in any dangerous situations. She has not had any physical contact with the defendant. So when you take all that into consideration, I don't think cash bond is really appropriate, especially with the lack of criminal history. I would also note, in terms of is he likely to appear in court, he has taken the painstaking process of hiring a private attorney while he has been in custody. Not an easy thing to do. So I think the fact that he has done all that shows that he intends to stay here and face these charges. I would also note that Mr. Bransky is former law enforcement. He was with Dane County Police. That is why he is in segregation, for his own safety. So I think that's also relevant, and that it shows that he has good character, that he is likely to follow the law and be present. As far as the not to go armed conditions and forfeiting all firearms conditions, those are an extremely limiting infringement upon someone's constitutional rights. It's been established over and over again by our Supreme Court that the right to bear arms is a constitutional right. And it is not appropriate to put a prohibition on that right when there is no real evidence that it is necessary. In this case, there's no evidence that Mr. Bolansky brandished a firearm against the victim or threatened to brandish a firearm against the victim, anything of that sort. The only mention of firearms is the cop allegedly asks if he has access to them, and she says that he's a hunter and he has a gun safe at his residence. And that's it. So when that's the only allegation, I don't really think a ban on possession of firearms is really appropriate.
I'm going to take a moment to take a closer look at this complaint, and then Attorney Dice will give you an opportunity if you want to make any last arguments. All right, Attorney Dice, first, before I forget, Kailey, is that the spelling?
Correct.
All right, any last arguments from you?
It's Kailey, sorry, just making sure you got that. Yeah, so council wanted to go through the facts here. We can go through the facts a little bit. So the defendant is 28 years old and 215 pounds, and the victim in this case is a 118-pound woman. He shows up at her house, keys into her apartment without an invitation. He then proceeds to hold her hostage. Let's call it what it is. Hold her hostage from 9 p.m. until 2 a.m., preventing her from leaving. As if this horror movie wasn't enough, he continues to physically abuse her during that time and make threats to her. So yeah, I do think taking his guns makes sense, considering he made threats. Statements from the complaint include, "You won't give in unless I cause you pain. Do you need me to punch you to realize? Is that a kink for you?" He's charged with a felony, Your Honor. He's charged with a Act 3 felony. He's charged with a battery. He's charged with disorderly conduct. He's charged with the misdemeanor intimidation of a victim. I believe taking his guns is absolutely important. I recognize as a former law enforcement officer, that might be difficult for him to go around without a gun. I do it every day. He'll be okay. Nothing further.
Just very briefly in response, there's mention she's 118 pounds, he's 220 pounds. She does allege that he kept repeatedly knocking her over and tackling her, and yet the detective indicated that they observed no visible injuries when they were speaking with the individual. There's no indication that any injuries were ever documented or recorded. So again, I think there's a common misconception that, yes, these are being charged. Yes, they're serious offenses, but all we have right now is the very beginning, right? It's just her statement as to what happened. There's no corroboration. There's no witnesses. There's no corroborating injuries. So to the extent that, yes, this is going to pass this stage, but I'd be hard pressed to think this is going much further. When you add in the fact that there was the thing that predicated this was a TRO filed by my client, granted to him against this individual under case number 26 CV 2253. And then this individual identifies him to the police. That stinks to me. That makes me think that there's something untoward happening here. So yes, it's far enough to go through this stage, but I don't think it's appropriate to be adding on conditions just because we feel like it.
All right, okay, guys, are you gonna tell me there's another CV case that's,
That was filed first by the victim against the defendant. The defendant, then in retaliation filed his TRO.
Okay, I see it. I think I've heard enough at this point. If this was just a question about whether Mr. Baranski was likely to appear in court, I would agree that a signature bond is appropriate. But these are Act 3 eligible offenses, so there are some questions about whether or not cash bail is appropriate to ensure protection of the public. I think that given what's contained in the complaint, I am satisfied that some cash bail is appropriate here. I'm going to order an amount of $1,000 cash. As conditions, I am going to order that Mr. Baranski not have any contact with Kaylee R. or any place she occupies. I'm going to order that he not go armed with any dangerous weapon. And I think that given the threats that are contained in the criminal complaint, it's appropriate for him to surrender his firearm while this case is pending. I'll order that too. Time limits for the preliminary hearing, counsel.
So what was that?
Time limits for the preliminary hearing.
Wait,
All right, I'll find Mr. Baranski has waived the time limits for the preliminary hearing. We'll schedule the matter for status. We're adjourned on this matter. Thank you.
Next up is Brian Deutsch for a bail bond hearing.
All right, this is 22 CT 204, State of Wisconsin versus Ryan Deutsch. Appearances, please.
Casey Dice for the state.
Ryan Deutsch appears in person in custody by student attorney Caroline Scott under the supervision of attorney Fredrickson.
All right, it looks like this case had an initial appearance back in November of 2023. There was a signature bond then there was a non-appearance by Mr. Deutsch on February 7th of 24. There was a bench warrant issued. There was a bail hearing then on October 25th of 24, where there was $200 cash bail set. That was posted. And then Mr. Deutsch didn't appear on February 6th of 25. There was a bench warrant issued, the $200 was forfeited. I think that's where we are.
I mean, don't get the $200 back. That's what
It has been forfeited at this point, the $200. Counsel, do you want to provide any information about the missed appearance?
We should probably check out an address too. Most recent address we received from CCAP is on Millwood Drive in Saukville, but I see one in Cedarburg in Philadelphia. So it'd be 663 West Ridge Drive.
No, okay, nothing, I didn't have arrived at the initial hearing on the 7th of February or something. Never arrived before, and then.
Your Honor, it seems like he was having some issues securing an attorney based on the CCAP record. It looks like there's some back and forth with trying to get a county appointed attorney. So I'm not sure what impact that might have had on his appearances, but I think that should be noted for the court. And other than that, I don't have any further information to provide.
Thank you. What's the state's position on bail bond?
Looks like the maximum available fine for this case, this misdemeanor case, is $2,000. given that we are now in a 2021, or sorry, the incident occurred in 2021. It was issued in 2022, and it is now more than halfway through 2026. I do think $2,000 cash is appropriate. The defendant simply is not willing to come back to court when he's arrested. He makes an initial appearance and he looks like he made a signature bond, didn't come back to court, and then was arrested again, $200, and then didn't come back to court. And here we are in 2026. You know, the state's cases don't get better. The defendant avoiding taking responsibility for the crime he committed, where he injured a real human out there in society, who's been dealing with this since 2021. He's just avoiding taking responsibility. The most the court can order is $2,000. I wish it was higher, but that's what I'm asking for, $2,000.
Counsel or?
Yeah, Your Honor. I mean, while we acknowledge that Mr. Deutsch has had some trouble appearing in court, I think we would be requesting a lower cash amount. As the state noted, this is a misdemeanor offense, and I'm not sure that Mr. Deutsch would be able to post that amount. And possibly when he's able to secure an attorney, that may make a difference in his appearance history. So for those reasons, we'd be asking for a more nominal.
Did you say he is now eligible for public defender?
I have information that he does not want a public defender represented, but it looks like in CCAP history that he was going back and forth with the clerk of courts trying to get a county appointed attorney.
Well, George, certainly, Attorney Dice makes a strong argument here for cash bail. This is an old case. You have sort of repeatedly failed to appear in court as ordered, and you've even posted some cash bail and still not shown up when you're supposed to show up. I think that cash bail is appropriate given all of those factors. And as well as just the sort of nature of the offense here, I'm going to order it in the amount of $500. So Mr. Deutsch, if you can post the $500, you will have to come back to court on the next date. Otherwise, the $500 will be forfeited and you will find yourself in the same position again. All right, we're going to be adjourned. The same conditions as were previously ordered will apply to the bail on this.
I think it was just the statutory.
Okay, great. Then we're adjourned.
Coach, right this way, please. Next up is Dimitri Sokali, appearing by Zoom.
Are you Mr. O'Kelly? If you are, can you give me a sign, a wave, or a thumbs up? Great. This is 26 CF 1270, State of Wisconsin versus Demetrius O'Kelly. Appearances, please. So there's two cases here. Thank you, Ray. The other one is 26 CM 1665. State of Wisconsin versus Demetrius O'Kelly. Appearances, please.
Casey Dice for the state.
Demetrius O'Kelly appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Fredrickson. Mr. O'Kelly, can you give me a thumbs up if you've gotten a copy of each of the complaints?
You likely also would have received.
There was an initial appearance on the CF case, June 12th of 26.
The way you look like you did class.
Okay, great. Okay, so we have received a copy of the complaint and waive its reading. And I don't have information about his eligibility, but I believe he's already represented by an attorney, so.
Attorney Paisley Hoffman.
Yes.
All right.
And Mr. O'Kelly, is the job center the best address for you still to get mail?
Yeah.
Okay.
All right, I've reviewed the CM complaint. It's a probable cause. What's the state's position on bail or bond on both of these? I will say that Mr. O'Kelly failed to appear at a preliminary hearing July 9th, and a warrant was issued.
Can I say something?
Mr. Kelly, if you want to tell me why you weren't in court on July 9th, that's fine with
I
me.
had asked the police officer, did I have a warrant out for my arrest and did I miss court? And then he said, you don't even have court. And then I was like, okay, so if I don't have court, I'm gonna pull up there. And then I was like, I literally forgot that I had court. And then I asked the police officer, did I have like a warrant? He said no. So I was like, I'm gonna call my attorney, but I don't have no phone. So I was like, okay, so like, what should I do? And I was like, if I go there and they say I don't have nothing to do, like, what would I do? So I was just like confused on how like it worked because like I kept checking in and being like, okay, and I actually forgot the timing because I don't know the day because I don't have no phone. I was asking people like what day it is, what time it is, and like people were like, oh, it's this date and this timing, but I was like asking the police that, and then they kept pulling up on me and like downtown because I was downtown the whole time. That's why, because like I can't take the bus, so like I can't go to like Aberg. That's why I was like asking y'all before, like, do I have any mail I should be expecting? So I was like, if I can like get definitive, what should I do? Because I was kind of like asking the police, do I go to court? Like, can like someone like help me out? Like, I'm like, can you CCAP me? Can you like help me like call my like person or something like that? And I didn't really get anything, but just like, you know, like you don't got anything, like you might just walk off, sir. Like, there's nothing that we can do for you.
Okay,
I
Mr.
can timestamps and
what-
like the days.
Okay, all right, Mr. Kelly. What's the state's position on bail or bond?
Sure. Well, despite having quite a few cases, it does appear like the defendant usually comes to court. I think I only see one bench warrant in his entire history, and that would have been the July 10th date. So while I was
Yeah, they told me I had court on the
Mr.
9th.
Kelly,
That's what I
Mr.
thought.
Kelly, Mr. Kelly, you had your, Mr. Kelly, we're gonna put you on mute because this is, the way we do things here is one person talks at a time. You had your turn, now it's Attorney Dice's turn. And then we're gonna give your lawyer a turn and then it's gonna be my turn.
so while his story was somewhat self-serving, and I don't necessarily believe all of it, he does have a history of appearing in court. So I think for the bail bond hearing, I do think he missed court. I do think some cash is necessary because he did miss court and he has previously made court, which makes me think that he previously knew how to check CCAP, knew to go to the law library, knew to call his attorney, etc. I don't think you can just ask a random police officer on the street, like, hey, do I have court today? And the expectation is that that's good enough. So I do think some cash is necessary. I think maybe $200 on the felony case, and then reinstating the non-monetary conditions. As to the misdemeanor, I think we're kind of in an inverse situation because he was out on bond on a variety of cases, and he's continuing to commit crimes. So we're asking for $500 cash on that one, a ban from State Street, and a ban from Taco Bell.
Is that the State Street map area and all Taco Bells?
Yes and yes.
Counsel?
Yes, Your Honor. We would be requesting a signature bond in both cases. As Mr. O'Kelly noted, he doesn't have a phone right now, so it's been difficult for him to keep track of his court dates. He's also, as he noted, not allowed on the bus, so that makes transportation difficult. And as the state noted, he very rarely misses court. So there's reason to believe that he would appear again in the future. He is also, I believe, given his I believe he's indigent and potentially unhoused, which would make any amount of cash bail prohibitive. In addition, they're looking through his history on CCAP. There have been various questions of competency over the years, and that could be impacting, the fact that he's picking up some new smaller cases. So for those reasons, we'd be asking for a signature bond here because it seems like there was just something that was going on in the last week that caused him to miss court and get this new situation.
All right, thank you. Well, Mr. O'Kelly may have a history of attending his court appearances, except for this last one, he did not attend, and he doesn't have a very compelling reason for not attending. Mr. O'Kelly is banned from the bus, but he was arrested at the Taco Bell on State Street. Mr. O'Kelly, that is walking distance to this courthouse. You could have walked here to find out when you had court. That would have been the best source of information. I think that given his failure to appear and the nature of the allegations that are contained in this CM case, some amount of cash bail is appropriate. I'm going to order $100 on each case. The same conditions will apply to the CF case. On the CM case, I will order that Mr. O'Kelly be banned from State Street, not the map, just the street, and as well as the Taco Bell that's on State. The CF case still needs a preliminary hearing.
Maybe previously we handled it, but I think it's not appropriate one.
Yeah, let's do that, please.
All right. Then it'll be adjourned.
Next up is Maurice Carpenter. Carpenter?
This is 26 CM 1173, State of Wisconsin versus Maurice Carpenter. Appearances, please.
Casey Dice for the state.
Maurice Carpenter appears in person in custody by student attorney Caroline Scott under the supervision of attorney Frederickson. We have received a copy of the complaint and waive its reading. Mr. Carpenter is eligible for public defender services, and is this the best address for you? I don't know where that. No, is it this one? No, do you want to update it with the court then today? Okay. You can just say that. Okay, can we update his address, please?
Yes.
2025 West Brook Lane. Brook. No.
And what's the zip code? We said, hey,
I've reviewed the complaint. It states probable cause. What's the state's position on bail or bond?
State's asking for a signature bond with no contact with the 6200 block of Mayfield in Middleton, and no contact with Angelique K. Angelique is spelled ANGELIQUE. Last name K.
Any objection?
No objections.
Say Mayfield or Maywood?
I said Mayfield.
Yeah, the complaint says Maywood.
Let's find out.
It's me.
Let me get to the police reports. Maywood.
All right, order of signature bond, Mr. Carpenter. While this case is pending, you are not to be in the 6200 block of Maywood Avenue in Middleton, and you are not to have any contact with Angelique K. When you leave here, you'll get your next court dates. Make sure you come back to court. All right, order.
Next up is Brent Schultz, attorney by Zoom. Just want to give you a heads up.
Can see someone on the other side of that door. If that's you, Mr. Schultz, will you give me a sign, a thumbs up, a wave, anything? All right, this is 26 CM 1667, State of Wisconsin versus Brent Schultz. Appearances, please.
Casey Dyke for the state.
Brent Schultz appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Wyndham. Mr. Schultz, have you received a copy of the complaint? You can just give me a thumbs up.
Yeah.
Okay. And is the address on the complaint correct? That address on Saturn Drive?
Correct.
Okay, and he is eligible for public defender representation.
All right, I'm looking at the criminal complaint. The charging portion was a misdemeanor bail jumping. It says that the crime is, or specific, the alleged bail jumping here, says that it was a violation of condition that he shall not have any contact, direct or indirect, with KMS. That's listed under the misdemeanor bail jumping portion as well, but the body of the complaint mentions a KAS.
Let's find out.
And then there's a section here that says the individual identified herein as KAS is the same person identified as KAS in the bond conditions.
Commissioner, there is a publicly filed file affidavit attached. It refers to the victim in both ways. It appears that the last name is a compound last name, and that's the relation.
Take a look at that.
That is correct. It's KAM-S is her name.
All right.
It's very obvious when they have your first name listed out. But not so much with the play.
All right. Well, suppose that's the initials are close enough, especially when viewed in with the probable cause statement to find that probable cause exists in this complaint. I'll enter not guilty pleas on Mr. Schultz's behalf. What's the state's position on bail or bond?
The state's asking for $100. He is charged here with violating a very specific condition of bond, not to have contact with KAM-S. And here he was having contact with her. I believe she thought she might have been being nice, letting him in off the street because he was saying it was hot out. But then he proceeded to go in and act manic to the extent that she felt she needed to alert law enforcement. So we're asking for $100 to acknowledge that this is yet another violation of bail. No contact with KAM-S, not to use or possess controlled substance or paraphernalia without a valid prescription. Nothing further.
On behalf of Mr. Schultz.
Your Honor, we'd be requesting a signature bond here. I believe that this is a situation between a parent and a child who is having a mental health crisis based on what's contained in the complaint. And when she called, I think that a CARES team was first sent out for help here. So it seems like Mr. Schultz may be having some mental health difficulties and is indigent. So for those reasons, we would be requesting a signature bond.
I was just looking to see whether Mr. Schultz has appeared at prior, on prior dates. I only see one on July 10th, but it looks like he was there. Given the absence of any information that he's actually missed any court appearances, I'm going to order a signature bond in this case with the conditions it's requested by the state. Mr. Schultz, you'll get your next court dates before you leave. Make sure that you continue to come back to court when you're supposed to. We're adjourned.
Next up is David Plaza on Tuna.
This is 26 CM 1666. State of Wisconsin versus David Plaza on Tuna. Appearances, please.
Casey Dice for the state.
David Plaza Antuna appears in person in custody by student attorney Caroline Scott under the supervision of attorney Wyndham. We have received a copy of the complaint and waive its reading. Is the beacon still your best address?
Yeah.
Okay. but for mail, I can put the beacon. Okay, okay, the address is correct. And Mr. Plaza Antuna is eligible for public defender representation.
All right, I reviewed the complaint, states probable cause. What's the state's position on bail or bond?
The state's asking for $1,000 cash, no contact with Daryl M., no use or possession of alcohol, and a ban from the 600 block of East Washington Avenue. The defendant in this case is violently assaulting strangers while drunk in violation of his bond conditions after previously posting $250 cash. He has multiple Act 3 cases open to include this one. He hasn't missed any recent court dates, but that's not necessarily a credit to him. That's because he keeps getting arrested prior to his next court date. This is his fourth criminal case since May 28th of 2026. Cash is needed given the Act 3 nature of the offense and the defendant's complete disregard for the court and its orders to abide by the conditions of bond, such as come back to court and commit no new crimes.
On behalf of Mr. Plaza Antuna, actually, before you speak, Attorney Dice, Daryl, D-A-R-Y-L.
It's D-A-R-R-E-L-L, last name M. What's that?
Okay. And just what it was not that spelling this.
On behalf of Mr. Plaza Antuna.
Yes, Your Honor, we would be asking for a signature bond or at the least a much more nominal cash bail amount. Generally, these are, although there is some Act 3 offenses involved, these are disorderly conducts with alcohol involved. And I think it's clear that Mr. Antuna is struggling with potentially a drinking problem here. I spoke with Attorney Anderson, his current counsel, and he indicated that that these cases were many of these cases were set to be resolved tomorrow for probation. He's also connected with CCS and has a caseworker through them. And he has very recently found himself homeless, which could also be somewhat of an explanation for this situation here. So for those reasons, and again, he recently has appeared in court out of custody. So I would note that for the court as well. And these crimes are frequently taken down to tickets, which again is an indication of the level of seriousness of some of his offenses. So we would again be asking for a signature bond or at least a much more nominal cash amount.
Okay, this is not just a disorderly conduct. The complaint also alleges a battery. According to the complaint, Mr. Plaza Antuna rushed up to another person aggressively and punched him one time in the face with a closed fist. It's an Act 3 eligible offense. I'll note that there is a public safety assessment on file. It puts Mr. Plaza Antuna at a 5 of 6 on the new criminal activity scale and a 4 of 6 on the failure to appear scale. It notes one prior violent conviction and failures to appear pretrial that are older than 2 years. I think it ultimately that document recommends that cash bail. I agree that cash is appropriate under this circumstance. Under these circumstances, I'm going to order cash bail in the amount of $500. I will order that as a condition of his bond. Mr. Plaza Antuna have no contact with Daryl M. and not be in the 600 block of East Washington Avenue.
No alcohol.
And no alcohol. Thank you. Usually it's going to be adjourned on this case.
Yeah, this way, right this way. Next up is Tyann Pool, appearing by Zoom. Forfeiture.
Cool.
All right, I can see someone on the other side of a door. Is that, if you are Tyann Pool, will you give me some sort of sign, a wave or a thumbs up? Okay. This is 26 FO 1352 Dane County versus Tyann Pool. Appearances, please.
Casey Dice for the county. The defendant appears via Zoom from Dane County Jail.
All right, good afternoon. I have in front of me a forfeiture complaint. It charges you with two counts: county obstructing or resisting an officer and county disorderly conduct. These are non-criminal ordinance violations. They carry no potential jail sentence, just a forfeiture of money. I am going to ask you how you wish to plead. But before you answer, I want you to know two things. The first is that no matter what your answer is, this forfeiture matter will not continue to hold you in jail. The second is that sometimes the county wishes to make an offer to resolve these matters today. I'm going to ask Attorney Dice whether he wants to make any offer to resolve this matter today, and then you can tell me what you want to do. Counsel?
Plead to either count one or count two, her choice for court costs.
All right, ma'am, the county's indicated that if you wish to enter a guilty or no contest plea to either one of these counts, they'll move to dismiss the other one. I will order that you pay court costs. That's $114.50. I can give you 60 days in which to pay that. You can also enter a not guilty plea, in which case we'll schedule the matter for further proceedings. Either way, ma'am, you're not going to be continue to be held on this matter. How would you like to plead?
Your Honor, picked up off the street by Officer Hernandez, picked out of a crowd randomly. And when I was brought in here yesterday, I was attacked by police officers in custody because I have a mental health disorder and I was upset. So they locked.
All right, it sounds like she's entering. What I'm going to do is enter a not guilty plea on her behalf, and we'll schedule the matter for further proceedings. Ms. Poole, if you'd like a jury trial, you have to make that demand in 10 days. And in writing in the next 10 days, and you have to pay non-refundable jury fees of $36. Otherwise, the matter will be tried to a court. You'll get another court appearance on your way out, but like I said, this isn't going to keep you in jail any longer. You'll be released today unless there's something else I don't know about holding you. All right, we're adjourned on that case.
Next up is Alicia Patterson.
This is 26 CF 1573, State of Wisconsin versus Alicia Patterson. Appearances, please.
Casey Dice for the state.
Alicia Patterson appears in person in custody by student attorney Caroline Scott under the supervision of attorney Wyndham. We've received a copy of the complaint and waive its reading. Is the Beacon the best address for you? Yes. Okay, the address is correct. And she is eligible for public defender representation.
I've reviewed this complaint. It states probable cause. What's the state's position on bail or bond?
The state's asking for $2,500 cash bond, no contact with Ty L, it's T-Y, last name L, or Balkis A, it's B-A-L-K-I-S, last name A. This is, defendant is charged with two Act 3 eligible offense, one of them being a Class E felony, the robbery with use of force. In the complaint, she is alleged to have physically assaulted and then stolen from the victims. The victims knew her by name and provided a name and description. Prior record. Looks like I'm seeing bench warrants, July 9th of 24. April 3rd of 24. And October 30th of January 29th of 24 and October 30th of 23. As far as prior Act 3 offenses goes. It appears It appears this is the first time being charged with an Act 3 eligible offense. She is a convicted felon at this point, but those crimes involved retail theft and crimes of that nature. So I do think cash bond is appropriate. I would ask the court to follow the state's recommendation.
On behalf of Ms. Patterson?
Yes, Your Honor. Ms. Patterson is indigent, as noted by the fact that she's eligible for public defender representation, as well as the fact that she is unhoused. So any amount of cash bail would be prohibitive, but we do understand that there is a serious offense charged here. So we would be asking for a much lower amount of cash being set today. Additionally, she has a 7-month-old child on the outside that she is hoping to get back to as soon as she can. And as the state noted, a lot of her previous offenses are retail thefts. So this is kind of an outlier as far as her history goes. And yeah, I think that's, for those reasons, we would be requesting a much more nominal cash bail be set, because anything, she won't be able to really post anything at all.
Well, the parties essentially agree that this is a cash bail case, and I tend to agree with you both. Either under either an Act 3 analysis or a failure to appear analysis. I have a series of missed court appearances from 23 and 24. And Ms. Patterson is charged with a serious offense. It carries a significant maximum penalty, which itself gives her some reason not to appear in court, but also calls for an Act 3 analysis. She's charged with a robbery with use of force. It's serious. It does suggest that cash bail is appropriate to protect the public from her. I am going to order cash bail in the amount of $1,000. I will order that as a condition of her bail. Ms. Patterson is to have no contact with Ty L or Volkus A. Time limits for the preliminary hearing, counsel.
Yeah, we'd like to keep them intact, Your Honor.
We'll schedule the matter for a timely preliminary hearing. All right.
Next up is Colleen Connors.
This 26 CM 1670, State of Wisconsin versus Colleen Connors. Appearances, please.
Casey Dice for the state.
Colleen Connors appears in person in custody by student attorney Caroline Scott under the supervision of attorney Wyndham. We have received a copy of the complaint and waive its reading, and Ms. Connors is eligible for public defender services. And that's okay, and the address on the complaint is correct.
I've reviewed the complaint. It states probable cause. What's the state's position on bail or bond?
The state is supportive of a signature bond. We're asking for no acts or threats towards Andrea H. and no contact with Roberta G. We're asking that there be a ban from the victim's apartments, despite the no acts or threats with Andrea H. We're asking for a ban from their apartments and no alcohol.
That's not. Okay.
Yeah, the way I read the complaint is that these two people lived in the same building. Is that your understanding, Anthony Dyson? If so, is the request just the unit or the building?
Well, that is my understanding, to answer the court's question. It says apartment, so let's use the smallest version of what apartment might be. So just the unit.
Any objection?
To that end, I believe that no objection, generally, except for that last condition, Ms. Connors also lives in that apartment building. So as long as it's just that particular unit, I think then that's acceptable to us. But if not, then we would prefer that no threats or acts of violence order be instated instead.
Order signature bond. Ms. Connors, while this case is pending, we're going to order that you not direct any acts or threats of violence toward Andrea H. And when you say victims, we're talking about Andrea H. is the person's apartment we're talking about, or is that the Roberta G? I could see Ms. Connors nodding her head that we're talking about Roberta G.
I think it's both. So I'm asking for no acts or threats towards Andrea. I'm asking for no contact with Roberta, and I'm asking for a ban from either of their apartment units.
Okay.
Your Honor, if I can quickly, I suppose I would raise a question then on the no contact for Roberta, since they do all live in the same building. I think like passing each other in the hallway incidentally could constitute a violation there. So we would be asking for no acts or threats.
I think Ms. Connors can manage to live in the same apartment building with these people and not have any contact with them. I think that's reasonable. She's nodding her head and gave me a thumbs up. So I think she thinks she can manage it too. Direct no acts or threats of violence toward Andrea H. and not be in her unit, apartment unit.
Sure.
And no contact with Roberta G. And that you are not to be in her unit either. You're not to possess or consume any alcohol while this matter is pending either. All right, Ms. Connors, when you leave here, you'll sign your bond form and you'll get your next court dates. Make sure you come back to court on the dates that are listed on that form. All right, we're adjourned. Rachel?
All right, next up is Sarah Cutrano.
This it?
Mhm.
Sure, I just want to. Yes. I don't know if that's really good.
All right, this is 26 CM 1668, State of Wisconsin versus Sarah Cutrano. Appearances, please.
Casey Dice for the state.
Sarah Cutrano appears in person in custody by student attorney Caroline Scott under the supervision of attorney Wyndham. We have received a copy of the complaint and waive its reading. Is this? Okay, and we would like to update the address to 925 Owen Street, Lake Mills, zip code 53551. And Ms. Cutrano is eligible for public defender representation.
All right, I've reviewed this complaint. It states probable cause. What's the state's position on bail or bond?
The state is asking for $500 cash. She very recently missed court in Columbia County for June 30th of 2026. She had an IA. So she failed to appear in Columbia County on June 30th. Then she had an IA on July 7th, 2026 in the Jefferson County case 26 CF 320. In that case, she posted $250. She made the same promises that she would hear, right? I promised to come back to court and commit no new crimes. And here she is on what date? July 16th. Less than 10 days after posting $250 in Jefferson, doing these allegedly doing these crimes, one of which is is an Act 3 eligible offense. She has prior domestic battery conviction in Dodge County, case 24 CF 391. On top of the cash, we're asking for no contact with Colin S. Nothing further.
COLIN.
Correct.
The PCF David has COLLI.
Yeah, that's what she said, right? Yeah.
Okay, sure.
Is that what you said?
No, but that's okay. I thought we were talking about 1L. Counsel, on behalf of Ms. Cutrano.
Yes, Your Honor. We would be asking for a signature bond in this case, or a much more modest cash bail amount. Ms. Cutrano is indigent and has no ability to post any amount. And to that end, she is on a hold for a Columbia County case. So I'd like to note that for the court as well. She does have 2 children who live with her in the area. And I also want to note that Ms. Cutrano, when she came out, asked me about the availability of pretrial services and if there might be a scram bracelet availability, which I understand right now there isn't, but I think goes to the fact that she acknowledges that she's suffering with some substance abuse issues, and that's kind of seems to be underlying a lot of the cases here. So there is some expressed desire for rehabilitation and improvement here. And she had also mentioned to me that she has been in contact was it the Jefferson County?
Columbia County.
The Columbia County, yeah, she'd been in contact with them there and was actually set to turn herself in, as far as I understand. So I think she has displayed, some awareness and some remorse for the situation. And like I noted, any amount of cash would be prohibitive for her, and she's also already sitting on a hold. So.
All right. Well, the question is about bail, whether Ms. Cutrano is likely to come to court as required. And Mr. Cutrano, I have the misdates that were referred to by Attorney Dice. I have a public safety assessment here on file, which shows that you have 2 or more failures to appear pre-trial in the past 2 years, but none that are older than 2 years old. They have a scale here on the new criminal activity scale. They have you on a 6 of 6. And on the failure to appear scale, they have you on a 5 of 6. I think given the missed appearances, the allegations that these offenses happen while you're out on bond, I think there's reason to believe that you're not going to appear in court. There are other considerations under Act 3 about whether or not cash bail is necessary to protect the public, and these are Act 3 eligible offenses. I think that some cash bail is appropriate here, given your failures to appear. And I'm not sure it needs to be $500. I'm going to order it in the amount of $350. Ms. Cutrano, I will. With respect to the no contact, I see that the criminal complaint says that he waived the 72-hour no contact. Do you have any other information about that, Attorney Dice?
I do not.
Okay.
Wait. No.
It says that on page 4 of the
Right.
complaint. As a condition of bond,
In contact through the chain.
all right, Mr. Turner, I want to make sure that you hear the rest of what I have to say here. In the event that you post the $350, I'm going to direct that while you're on bond, that you're not directing any acts or threats of violence for Colin S. I'm not going to order the no contact, given the information that's in the criminal complaint that he waived the no contact provision, except for Attorney Dice might have some additional information.
Yeah, no,
Mind.
I would point the court to Dodge County 24 CF 391, where CJS was the listed victim on a misdemeanor battery. It was originally referred in or charged as a strangulation and suffocation. I see him. Other charges, 24, he was listed as a victim on 24 CF 393, which was dismissed but read in to the other resolution. That was Dodge County case back in, incident dates of 2024. I think given that, maybe contact is a decision best left to the branch judge.
All right, I do now understand why the state's asking for it. I'm still not going to order it. So the conditions will be as I indicated. Okay, we'll be adjourned on this one.
So all she
Thanks, everyone.
is,
All she said was, you can. Not a no contact, it's just you can't. Should be able to help you.
Oh,
And we'll get you an attorney from where you're listed.
You think we're done?
I think so. I've closed all the windows on my screen. So.
All right, Mr. County, right this way, please.
You have
That's everyone's
$350
day.
cash set here.